Hi, everyone. Judge Andrew Napolitano here for Judging Freedom. Today is Wednesday, September 7, 2022. It's about 2:35 or 2:40 in the afternoon here on the East Coast of the United States. What should the Justice Department do with the decision by Judge Eileen Cannon of the United States District Court for the Southern District of Florida, that portion of Florida that covers where former President Trump lives and where the federal courts are located? With her decision that she released on Labor Day of all days, when the courts are closed, saying that she will appoint a special master to review the documents that the FBI seized from Trump's home and prohibiting the Justice Department from using the documents until the special master gives his opinion on them and she ratifies or rejects that opinion. In my opinion, Judge Cannon made a series of rookie errors, and the Justice Department really needs to appeal this decision. It's very much an outlier, meaning it's not soundly based on existing law, and there really is nothing else like it, and it will establish a terrible precedent. Number one, she says Trump may suffer serious embarrassment if these documents should be leaked. Well, that's not a reason to appoint a special master. That's a reason for him not to have possessed the documents in the first place. That's also not a legal argument. That's a political argument. There are a lot of people who believe that Trump will be embarrassed and that the goal of the Justice Department is to embarrass him. That's a legitimate political view, but it's not a legal view. She said she's going to appoint the special master to decide what is subject to executive privilege and what isn't. Well, the special master is not in the government, and that's a legal decision. A, does executive privilege exist? And B, are any of these documents subject to it? Only she can decide that and not a special master. The decision about whether or not he has executive privilege has been ruled on rather weirdly by the Supreme Court in United States versus Nixon. In my opinion, the former president has no executive privilege. That's because U.S. v. Nixon says if a former president wants executive privilege for documents he saw while he was president, but he wants the privilege after he leaves, the present president must exercise that privilege for him. And Joe Biden, for better or for worse, and for whatever the reason, said he's not going to do that. So it's pretty clear to me that there is no executive privilege. But whether or not there is, and if so, whether any documents apply to it, is for her to decide and not for a special master to decide or to recommend to her. That is her function, to decide what the law is. She made much of her rulings, if you read it, it's a political document. She made much of her rulings based upon whether or not she believed the arguments of the lawyers for the government. Again, that's not her function. Her function is to rule on the law, not on the credibility of the lawyers before them. Judges don't assess credibility unless they're the fact finder in a case, meaning there is no jury and the judge is hearing a witness and deciding whether the witness is believable. But judges don't make rulings on the basis of whether a lawyer is believable. Why? Because lawyers often make arguments with which they personally disagree because they represent a client. So they may not make the argument in a credible way. That is no reason to punish the client. The client's case, in this case, the Department of Justice, should rise or fall on what the law is, not on the credibility of the lawyers that the DOJ sent in the courthouse. And finally, she violated what we all know is the separation of powers. Congress writes the laws, government and the executive branch, the president, everybody that works for him, including the DOJ, enforce the laws. The courts decide what the laws are and what the Constitution means and how it affects the laws. But for her to interfere with the core function of another branch, to say you have to stop a portion of this prosecution, that violates the separation of powers. How did she do that? Judge Cannon told the prosecutors they can't use these documents. Well, what the hell does that mean? They can't use them. Can they think about them? Can they discuss them? Can they show them to other lawyers in the DOJ? Can they do research based on them? If a witness or a name in there is about to die, can they interview that person? If that person is in the US and is about to flee, can they restrain the person or interview the person before they leave? The fact that she told them they can't use the documents, a pedestrian, inartful turn of phrase, materially interferes with a federal prosecution. For all of these reasons, and she's being criticized all across the board by conservative legal scholars and lawyers and ex-prosecutors and those on the other side of the aisle. For all of these reasons, I believe the DOJ should appeal. Now, here's the DOJ dilemma. If they comply with her ruling and don't appeal it, as former Attorney General Bill Barr said, this is just a rain delay. This will take a month, and then they're back to where they started. On the other hand, if they appeal her, this could delay everything for a couple of months. Defendants, in this case Donald Trump, always like delay. Government never likes delay. It has its case, it's ready to go, doesn't want to wait because it doesn't know what could happen in the interim. My opinion, I agree with Bill Barr, and I have rarely agreed with him. The DOJ should appeal Judge Cannon's ruling. I think that an appellate court immediately will enjoin the ruling, which allows the Department of Justice to continue to use the documents in its investigation and prosecution. And then I think it will rule against her. Judge Napolitano for Judging Freedom.